Hi, I'm Ron Steiner from Chapman University Department of Political Science, and I'd like to talk to you a little bit today about the Constitution, its significance, and its meaning. A lot of times when people talk about the Constitution, they talk about constitutional history, founding fathers, that sort of thing. And all that's great. I teach a class on constitutional history myself, but I thought I'd talk today about the constitutional present. That is, what's going on with this vaccine mandate, for example? Is it legal? Is it specifically constitutional? So let's talk a little bit about that. And let me share a screen and show you some slides that I've developed on that. So President Biden has announced that he wants to have this vaccine mandate. Now, first off, I'm putting that in quotation marks because I think it's a little more complicated than that. For example, the mandate is really a testing mandate for most people. That is, people in the private sector are being told they should be tested, or they could get an exemption from weekly testing if they get the vaccination. So in that sense, it's not really a vaccine mandate for that large majority of people. Now, for a significant number of people, specifically those who work for the federal government or work for federal contractors of various kinds, it is kind of a vaccine mandate. The program doesn't say get tested or get a vaccination. It says get a vaccination with the usual caveat that there are some health and religious exemptions for these vaccinations. So let's talk about these mandates in a little bit more detail. The first mandate is the true kind of vaccination mandate. But even then, mandate's kind of a tricky word because it's a conditional requirement. Now, the conditions are pretty steep, right? Get a mandated vaccination or lose your job. That's a tough condition. Most people really don't want to put up with that. But it is different from a true compulsory vaccination. And I want to kind of note that phrase, compulsory vaccination, because it's an important part of the story. So this is not a compulsory vaccination. It's not a requirement, get a vaccination or else you'll be a criminal. It says, if you want to continue working in this workplace, you need to get a vaccination because of the reasons that we'll discuss. So it's a conditional requirement. It is a vaccine requirement with these religious and medical exemptions, with the sense that maybe they're tightening that up a little bit and not giving those out as easily as they used to. Again, this isn't for everybody. It's federal employees or people who work for federal contractors, and then with some more specificity with regard to healthcare workers, but only those who work in settings where there is Medicaid or Medicare funding. Now, that's a lot of places. People who work in Head Start programs that are directly run by the federal government, and then not most school teachers, but some school teachers, specifically those teachers and staff who work at schools run by the Bureau of Indian Affairs and the Department of Defense. So you need to think a little bit about why those limitations? Why is that the case? And then there's a second mandate that relates to employees at private companies, but only those with more than 100 employees. So again, why private? Notice it doesn't apply to state and local employees. And why this numerical limitation of 100? Again, this is really a testing mandate. It's a conditional testing mandate, right? Get the testing or give up your position. Tough terms, but it is conditional, again, not truly compulsory. And there is an exemption, again, for those who are vaccinated. This is expected to cover about 80 million workers nationwide. That's about how many people we think are employed in the private sector with companies of over 100 employees. Notice the penalty, kind of steep, $13,600 per violation, but it's imposed on the employer, not on the employee. The individual doesn't pay, the employer pays, with, of course, a lot of employees being told by their employer, we're not going to pay $13,600 just for the privilege of having you continue to work for us out of compliance with this mandate. Yeah, people are going to be fired, and that really is kind of the point. Well, what's the legal authority for all this? And the most important thing to note out of this presentation, perhaps, is the constitutional basis of federal power is very different from the constitutional basis of state power. State governments, as what we might call organic sovereigns, the governments that were created by the people in kind of organic way as they grew from settlements into colonies and then into self-governance. State governments have what political scientists and legal scholars call police powers. Now, that's not just the powers of those guys and gals who drive around in black and white cars with lights on the top. Police powers means, more broadly, the power to regulate on behalf of public health, safety, welfare, and morality. Regulate on behalf of public health, safety, welfare, and morality. So that's police, it's fire, it's restaurant inspectors, it's education, it's social welfare programs. It's most of the things that we think of as, kind of the responsibilities and capacities of government. And then the federal government has been delegated certain powers, certain limited powers, and significantly not police powers. So the Supreme Court, in various cases, has talked about state police powers. One that's most relevant right now, you may have heard about in the media, is Jacobson versus Massachusetts from 1905. And in that case, Justice John Marshall Harlan said, it is within the police powers of a state to enact a compulsory vaccination law. I'm going to pause there. Notice he says compulsory vaccination law. Massachusetts here wasn't fooling around. It wasn't conditional. It wasn't get a vaccination or forfeit your job with the state or with certain private employers. It was get a vaccination, full stop, period. If you don't, you're committing a crime, you're in violation of the law, and you'll be punished. So the state said, you have to pay a fine. The fine today would be the equivalent of roughly $150. That's a lot of money, but it's not gonna, kill most people's bank account, but still $150. Mr. Jacobson didn't want to get the vaccination, didn't want to pay the fine, and was kind of risking going to jail for contempt of court, not for failing to get the vaccination, but for actually failing to pay the fine. Now, the court says it is within the police powers of the state to enact a true compulsory vaccination law, get the vaccination, period. And then he goes on to say, with the court's concurrence, it's not for the court to second guess what the legislature has decided to do. It's for the legislature, not the courts, to determine in the first instance whether vaccination is or is not the best mode for the prevention of, in this case, smallpox and the protection of the public health. So you can force people to get a vaccination. And in discussing why the court thinks this makes sense, Justice Harlan points out, look, we've always done quarantine, and that's a pretty big imposition on people's liberty, right? It literally locks you up. And we can lock you up for quarantine purposes, even when you are apparently free from disease. That is, you're asymptomatic, right? You don't even look sick yet, but you've been exposed, or at least we think there's grounds to believe you've been exposed. And so we're going to lock you in quarantine until we've ascertained whether you're a threat to the community. So he's saying, look, we can put pretty big impositions on people's individual freedom in order to make sure that we're not spreading a dangerous disease into the community. Now, as I indicated, federal government really doesn't have true police powers in this sense. That is, power to regulate on behalf of public health, safety, welfare, and morality. If you think about it, we don't really have a federal police, right? We have an FBI, but that's different. They're not roaming the streets with cars, with lights on the top. We have Capitol Police, and we have some other specialized police for Washington, D.C. and elsewhere. Court refers to those as federal enclaves, where there isn't really a state to exercise sovereign police powers. But for the most part, federal government doesn't have police powers. And a really outstanding example of that is a case from 1995 called United States versus Lopez. Antonio Lopez had taken a gun to school. He was a senior in high school, and he had taken a gun to school, and probably a really bad idea, right? Such a bad idea that Texas actually had a law against it. This was all happening in San Antonio, Texas. And he was arrested by the San Antonio police, but for kind of odd reasons, he ended up being prosecuted by the federal government for violating a federal statute called the Federal Gun-Free School Zones Act. And the question in the case was, can Congress have a law like that? And the Supreme Court in Lopez said, no, that's just straight up police powers. That's not the kind of unique set of delegated powers that the federal government gets to exercise. Now, the federal government has extensive powers: national security, running the military, banking, minting money, copyright protection, a lot of other things that are related to what the Constitution calls interstate commerce and international commerce. So the core powers of the federal government are those interstate commerce powers and other kind of powers related to national security, money supply, the military, things like that. Not a general writ to exercise police powers, not a general authority to say, we're doing this on behalf of public health, safety, welfare, and morality. Well, so what's with this vaccine mandate? Isn't that kind of a health regulation? Well, the government, the federal government, can exercise something like police powers if the power that it's exercising is otherwise legitimate under either the Interstate Commerce Clause or the Spending Clause, or maybe its inherent authority to regulate the workforce, or maybe some other part of the Constitution. So, for example, in the case of United States versus Darby, it's a lumber company. There was some, various dangers in the workplace. The Congress had imposed a rule enforced by the National Labor Relations Board that set maximum hours and minimum wage for people working in certain industries, including lumber mills. There's arguably, probably likely, a police powers motive behind this, right? A concern about health, safety, and welfare. But the rationale was, this is interstate commerce. This lumber company is a big lumber company, and it's engaged in interstate commerce, and the federal government has authority to regulate interstate commerce. And similar but different kind of case, South Dakota versus Dole. This was a case under the Reagan administration. The federal government, Ronald Reagan and others, wanted to raise the drinking age nationwide to 21. Can the federal government just say 21 shall be the drinking age in the United States? Turns out the answer is no, because that's really police powers. That's kind of core police powers, right? Public health, safety, welfare, and morality. Different states set different ages. Some said 21, some said 18, some had kind of quirky, different, unique rules. Ronald Reagan wanted a national rule of 21. So how can we do that? Well, they use what we call the spending clause. It said, we, the federal government, will only give full highway funding for maintenance and construction of interstate highways to those states that raise their drinking age to 21. The other states aren't going to get that full funding because arguably, this is unsafe, this is unhealthy, this isn't good for, the general welfare for interstate commerce, that sort of thing. So we're not going to spend our money in states where we don't think the highways are properly administered. Can the federal government do that? And the Supreme Court in South Dakota versus Dole said, yes. South Dakota wanted to say, you can't force us to raise our drinking age. And the court said, they're not forcing you to do anything. They're telling you, you have a choice. You have a choice to raise your drinking age or don't get all the federal highway money that you would otherwise be entitled to. Feels a little extortionate to some people, but the court said, it's a true choice. You have the authority to keep the drinking age the way you want. Federal government has the authority to not spend money in your state if they don't want to. So there we have something like police powers being exercised under this spending clause. And then there's also just the inherent authority of the federal government to regulate, for example, its own workforce. So it can hire and fire employees, just like any other employer can. As long as it doesn't discriminate on protected status, it can say, these are the terms and conditions if you work for us. And so you can hire people and fire people if they meet terms and conditions or fail to meet terms and conditions. So let's look back at, again, these the terms of this mandate. The conditional requirement to receive vaccination, that first mandate, it applies to federal employees and to contractors working for federal employees. Well, federal employees, that's inherent authority of the government to regulate its workforce. And then contractors, well, that's spending clause. We're going to hire you to provide some service. Maybe it's just like food service in the Capitol building or something like that. but lots of other federal contractors. But we're only going to do it if you have a vaccinated workforce, because we think that's important. Spending clause is the rationale there. And then similarly, healthcare facilities, spending authority, Head Start programs, spending authority, and schools, notice only schools where there's federal spending. Really aren't that many Bureau of Indian Affairs schools or Department of Defense schools. We're not talking about the schools that are common, Orange County or, City of Orange or Irvine or Los Angeles or anything like that. Now, the second mandate, you remember, was for private companies with more than 100 employees. And, why private companies with more than 100 employees? Because of the Interstate Commerce Clause. The rationale for this is not police powers. It's just like US versus Darby. It's an interstate commerce claim. It applies only to private companies because it's kind of tricky to apply the Interstate Commerce Clause to state employees. State and local employees are kind of governed by the sovereignty of the state, and you don't really need it to cover federal employees, so only applies to private companies. And then the numerical limitation is really aimed at saying really small businesses, maybe Joe's bike shop, which is just Joe and his son working part-time. Maybe that's not interstate commerce. So small companies, we're not really aiming this at them. It's really just for bigger companies, partly because the enforcement's easier, but partly because the rationale of interstate commerce is more plausible. So again, what's the legal authority? Federal employees, it's inherent authority. You just need a presidential executive order, and that's the rationale that the Biden administration is using for that portion of the mandate. What about the Head Start programs? Well, they say within the spending authority that Congress has granted to the U.S. Department of Health and Human Services, we can make spending decisions about which Head Start programs we want to support. We can put strings attached, right? We always talk about the strings that are attached on federal money. Similarly, we put strings on the money that we have in school programs for the Department of Defense and the Bureau of Indian Affairs. So spending authority, spending clause again. And then Medicare and Medicaid has, again, a separate set of requirements for getting your health care facility covered by Medicare and Medicaid funding. They can put strings attached on it, and this will be a new string. You'll have to have your employees vaccinated. Then for private employees, right, it's interstate commerce. It goes in a different direction. And what justifies this, says the Biden administration, is not spending clause authority. That's not really the issue here. It's interstate commerce, and specifically, it's the Occupational Safety and Health Act, which set up OSHA, the Occupational Safety and Health Administration. This act was passed by Congress in 1970, and it said this agency, this administration, can set up standards for what constitutes safety in the workplace. And it could be things like people can't be expected to stand on their feet for too long, or people can't be expected to stay awake for too long, or the assembly line can't be too fast, people might get hurt. But it also has things like pollutants and toxic materials and other kind of elements in the workplace that might make somebody sick. So you have to have a certain amount of light, you have to have circulated air, you have to have other kind of conditions in the workplace that keep people physically well. And what the Biden administration is arguing is keeping people from getting sick with a pandemic virus. Well, that's covered too. And frankly, OSHA has been covering disease causing elements in the workplace for years. There are even some reports that OSHA put together in 2007 and 2009 that had nothing to do with coronavirus, but in the aftermath of MERS and SARS and other viruses that we had experience with, they were putting together standards to say, here's what it means to keep a workplace safe from harm to employees in an environment where there's a pandemic disease circulating. And now they're building on that. And they're doing it through what's called an emergency temporary standard. This allows OSHA to enact a standard after kind of putting out public notice. They don't have to go through the usual process, because the usual process these days can take about 3 years. And OSHA has kind of noted, kind of responding to a viral epidemic or pandemic, 3 years just ain't going to cut it. So if we're going to have rules about these kind of things, we might have to enact them pretty quickly, but they can only be in place for about 6 months. And then they'd have to be taken down and ultimately replaced by a non-emergency standard that went through the usual process. Notice from the enactment of OSHA, it says emergency temporary standards can be established without using the usual required notice and comment period, and they go into effect immediately upon publication. And the determination that's required from the Secretary of Labor, actually, is that employees are being exposed to a grave danger from exposure to substances or agents determined to be toxic or physically harmful, or from new hazards, and that this is an emergency that has to be done, has to be handled right away. OSHA, notice, doesn't cover state or local government agencies and units. Therefore, according to the Congressional Research Service, none of these rules would apply to state and local employees. Even things like fire departments, state and local government hospitals, emergency medical services, prisons, and others you can see there. So it really just focuses on private sector employees. And again, over 100, so that we can kind of say with some certainty, this is a business big enough to be impacting interstate commerce. So there's some questions then. Does this mandate make sense? Couple of different questions. I'm going to break them up into kind of 6 different questions, and question 6 has multiple elements. But just think about this. Is the inherent authority of the president enough to justify an executive order, notice, without any congressional authorization, requiring the vaccination of all federal employees? Some people would say yes. Some people would say no. Something to think about. Similarly, is the inherent authority of the president acting through an executive order with no congressional authorization sufficient to require the vaccination of all employees of federal contractors? Notice it stretches it a little bit. Well, that's a lot more people. Then think about these spending clause claims. You'd have to get into the statute, but are the authorizations that Congress established for these agencies enough to justify requiring school staff to be vaccinated in these BIA and Department of Defense schools? Again, maybe, maybe not. Similarly, the specific statutory authorizations for Head Start, is there enough leeway there to require the staff to be vaccinated? Maybe, maybe not. And then a much broader group of people and institutions, healthcare facilities and the staff in healthcare facilities, is the authorization to the Center for Medicare and Medicaid under Health and Human Services, is that sufficient to make this a mandate that they have to put in place in order to receive the funding? Again, maybe, maybe not. It's a statutory fight that's we're definitely going to see. And then let's look at these Interstate Commerce Clause issues for private agencies. So Congress did authorize OSHA to enact these emergency temporary standards. Is that enough to justify this kind of order requiring testing or vaccination for any private company with more than 100 employees? Maybe. OSHA definitely thinks it is. And again, not OSHA sort of acting today in 2021, but even back 2007, 2009, they kind of talked about these might be necessary. Is this a grave danger from exposure? The emergency temporary standards can be imposed when there is a grave danger from exposure to agents determined to be toxic or physically harmful, or from new hazards. Is the pandemic virus covered by that language? I have to say, some people would say, well, yeah, of course, right? You're making people sick in the workplace. You're essentially compelling people to show up at a place where they might get sick. So OSHA might have that kind of concern, but others might say no. And then finally, the really big constitutional question: if OSHA uses its authority to create these emergency temporary standards, would that be constitutional as a regulation of interstate commerce? Again, some people would say yes. OSHA thinks it is. OSHA is saying, look, interstate commerce includes, making sure that pandemic disease or hazards in the workplace don't impair the flow of goods and services in the US economy. Now, small businesses might not be enough to affect the economy, but you start having pandemic disease in a lot of parts of the economy, and you have things like supply chain issues, and you have, meatpacking plants that don't function, and you have some of the problems that we've already seen. So OSHA is saying to them, it seems self-evident, this is having an impact on interstate commerce. I don't know that everybody agrees. The eventual resolution of all these questions is right here. It's going to have to go to the Supreme Court, and we'll see what they decide. It probably could take a while, but I'm sure there will be court cases filed very quickly once the regulations are established, and we'll start getting some at least lower court judges really probably start at the intermediate courts of appeal, because for many of these cases, they can be pitched at that level. Others will begin in the federal district court, but eventually they're all going to have to be resolved by the US Supreme Court. That's really just the name of the game these days. So thanks for your attention. I hope that that was helpful and interesting. If you have any questions, you can follow up. Again, I'm Ron Steiner in the Department of Political Science. And thanks for listening in. Take care.